on cross-examination said, "Ms. Edwards, we've heard about your husband's injuries, but we haven't heard anything that was wrong with his vocal cords that would prevent him from singing you a song. And you're asking the jury to award you money because he couldn't sing you a song?" She said, "Oh, Mr. Marshall, you misunderstood. He can sing, he just can't remember it's my birthday." And 2 or 3 of the women on the jury started crying. Judge Marco put his head down on the bench and he looked up and he said, "Mr. Marshall, you have any more cross-examination?" And I'm confident that one ill-advised cross-examination question cost Norfolk Southern several $1 million.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
All right, welcome back to RVA Trial Lawyers, Richmond's trial lawyer podcast. We are very fortunate today to have John Shea, not only a great trial attorney in the Richmond area, but also my boss. He is right down the hall from me and somebody I get to interact with daily. Virginia Lawyers Hall of Fame, $12 million result, $11 million result, $10 million result, $7 million result, $6.5 million result, $5.1 million result, $5 million result, $5 million result, 4.2, 3.9, 3.8, 3.5, 3.25, 3.0, and there are a few more pages left to go. John, it is truly a privilege to have you here with us. Why don't you go ahead and introduce yourself to our listeners?
Well, my name is John Shea, and I'm a lawyer at Marks & Harrison. I have been with Marks & Harrison my whole career. I started here November 1, 1977, and it's been my only job. My whole career, been with one firm, been here the whole time.
And John, why do you do this work?
Well, it's the best, for me, the best type of practice to be engaged in. You get a chance to represent the little guy. You get a chance to try to slay Goliath. So I enjoy representing the little guy against the big and powerful. As the former Virginia politician Henry Howell used to say, it's a way to keep the big boys honest. So I enjoy that. From a selfish point of view, as a plaintiff lawyer, your income is unlimited. You can rise as high as your ability takes you. And number 3, it allows me to scratch an entrepreneurial itch because it allows you to be a businessman and do a little marketing and things as well as just practicing law. So it combines for me 3 things that I really enjoy.
John, the first few months at Marks & Harrison, for me, I remember you started telling a story about this trial you had against Norfolk Southern. And I'm certainly not going to steal your thunder, but John, would you mind talking a little bit about that case?
Yeah, it was a great case. I had the privilege of representing a fellow named Willie T. Edwards. His wife's name was Barbara. Willie worked for the city of Richmond in their sanitation department. I remember he made, at that time, $16,000 a year, lived very humbly here in Richmond in a very modest home. And he and some co-workers were working down in the Shockoe Bottom area. If anybody knows where Bottoms Up Pizza is, he was working down there on a flood wall. Richmond the federal government had built a flood wall to protect the businesses in Shockoe Bottom from flooding when the James River would overflow. And they were down there doing some work on the flood wall. And that flood wall has railroad tracks that run underneath it. They were Norfolk Southern railroad tracks. A little further north that day was a Norfolk Southern boxcar, and the boxcar was loaded with trash. And it was sitting on the yard. Unfortunately, the brake on the car was defective. And there was just a little slight angle to the terrain there. So the boxcar started rolling a little bit downhill, just started rolling a little bit. And one of the Norfolk Southern guys noticed, oh my God, the boxcar is rolling. And so he ran over and jumped up on it and went to try to crank down the brake on the boxcar, and the brake failed. So the boxcar by now was picking up a little forward momentum coming downhill. And they have what they call on railroad tracks derailers, where you can throw a switch, and when a boxcar gets loose, it's supposed to allow you to throw the car off if something like this happens. Well, the Norfolk Southern employees tried to activate the derailleur, but the derailleur malfunctioned. So this was the third malfunction. And so now the boxcar is really picking up steam, rolling down the hill. The Norfolk Southern employee jumps off. He bails off because he sees this, I can't stop this thing. So now it's like a proverbial runaway boxcar coming down the hill, and Willie Edwards was working on the other side of the flood wall, and the boxcar went slamming into the flood wall, slammed into Willie, and brain damaged him, injured him badly, put him in, at that point, MCV Hospital, now VCU Health, of course, put him in the hospital for weeks. We were retained to represent him. There were several other injured City of Richmond employees who also retained counsel. There was 4 or 5 of us that were retained. The late Don McEachin, Congressman McEachin, represented one of the injured parties, and there were several other local colleagues that were retained to represent injured folks. We made a claim against Norfolk Southern. Norfolk Southern would not really fairly negotiate with us, so we had to file suit against Norfolk Southern. We filed in the city of Richmond. Case was assigned to Judge Marco, Ted Marco, now retired, of course. A couple of the cases settled before trial. Ours did not. About a week before trial, Norfolk Southern admitted liability at the last minute. Within the last week, they admitted responsibility, but we're still contesting the damages for the case. And so we went to trial against Norfolk Southern.
I remember you telling me about some last-minute negotiations right before the trial started.
Yeah, we had negotiations with Norfolk Southern. I don't recall whether there was a formal mediation. I don't believe there was, but they offered Mr. Edwards $2 million, and this was a long time ago. And $2 million, a lot of money now, but it was really a lot of money back then. Our demand was $4 million. We got to the courthouse, met with Judge Marco in chambers the morning of trial, and he asked me what my demand was, and I told him, and defense counsel, who's Bruce Marshall, now deceased, Bruce told the judge what his offer was. There were Norfolk Southern representatives there, and the judge said, well, I see what we're going to do here. I mean, we're going to split the difference. We're going to settle this case for $3 million. John, you go see if Mr. Edwards will take $3 million. So I talked to Mr. Edwards in the hall. He didn't want to accept $3 million, but he said he would. Came back in. Norfolk Southern said no, they would offer $2,050,000. So they offered another $50,000. And we said, well, we're not going to settle it for that, Judge. And he said, fine. It was set for a week-long trial. And we went, I think, 4.5 days of the trial. And the most memorable moment, and I don't say this to pick on Bruce Marshall because I was very fond of Bruce and he was a good lawyer, but Mrs. Edwards was on the stand. And remember, Willie had had a brain injury, and his neurosurgeon had already testified that he had a brain injury. And I asked his neurosurgeon, well, how do you know, doctor, that he had a brain injury? You can't see it. He said, well, I had put a tube in his head, and I noticed that some of his brain matter was draining out of the tube into a bag by the bed. So I was pretty sure he had a brain injury. So the jury knew he had a brain injury. But Mrs. Edwards was on the stand toward the end of the trial, and I asked her to tell the ladies and gentlemen of the jury how the brain injury had affected Willie. And she gave a few examples, and she said, but the most telling example is that my husband always had a thing he did for me on my birthday where he would learn what was my favorite song. He would find the music to the song and he would sing it to me. And she said he didn't do it on my birthday this year. And on cross-examination, Mr. said, Ms. Edwards, we've heard about your husband's injuries, but we haven't heard a thing about anything that was wrong with his vocal cords that would prevent him from singing you a song. And you're asking the jury to award you money because he couldn't sing you a song? She said, "Oh, Mr. Marshall, you misunderstood. He can sing, he just can't remember it's my birthday." And 2 or 3 of the women on the jury started crying. And I remember Judge Marco put his head down on the bench in his hands. And he looked up and he said, "Mr. Marshall, you have any more cross-examination?" And Bruce said, "No, I don't, Judge." And he sat down. And I'm confident that one ill-advised cross-examination question, which I still will never forget, probably cost Norfolk Southern several $1,000,000. So anyway, the jury went out not too long after that, and they were out about an hour, maybe less. And they came back and, they had the proverbial knock on the door, and the bailiff said, "Can I help you?" And they said, "Yeah, we've got a verdict." And he said, "All right, well, come on in." Everybody's thinking, my God, it's not even been an hour. And there was a very famous or popular and famous defense lawyer that practiced law in Richmond at the time, Lenny Lambert. Lenny was a very wonderful guy, and he did a lot of insurance defense work. And Lenny had been in there to listen to closing argument and watch some of the end of the trial that day. And he leaned up to me and he said, "John, sit tight, buddy. In just a minute, there's going to be another train wreck in this courtroom." And so the jury comes back in, and Marco does the usual, "Have you reached a verdict?" And they say, "Yes, we have," and hand up the piece of paper, the verdict form to the jury. And we're sitting there, and he runs through each member of the jury. "Is this your verdict, Mr. Smith? Is this your verdict, Mr. Jones? Is this your verdict, Miss whatever?" And they're all, "Yes, sir, yes, sir, yes, sir." And then he reads it out, $10 million. And I had been praying. I was just praying, "God, please, please let me get more than the $2,050,000 they offered." And they gave us $10 million. So it was a good day for Mr. Edwards. He and his wife, Barbara, now live in a very large mansion in the west end of Richmond on the golf course. So Willie's doing well on Norfolk Southern.
Amazing story. Sounds like an incredible trial. One of the things I will never forget when you told me that story many months ago now is really the care that you had for Willie after this trial. You didn't just go back and move on to the next case. You made sure Willie was taken care of.
Yes, I stayed close to Willie. Willie, of course, was well financially. I think we eventually structured the money of his case so that he would have a stream of income through his life and wouldn't be tempted to blow the money. We helped Willie, went with him and the realtor to find their home, and he wasn't a sophisticated guy, so I helped him with the transaction of buying his home. He lives in Wyndham on the golf course out there.
John, would you actually mind sharing that story about helping him find his home?
Yeah, it was funny. He had contacted a realtor. Willie was African American, and he wanted to live in a nice neighborhood. And so he had heard of Wyndham, so he contacted the realtor. The realtor picked him up and Barbara at my office, and we all drove out to Wyndham. And of course, the realtor had no idea about Willie's financial situation. She just knew he was looking for a house. So Wyndham, if you know that subdivision, they break the neighborhoods down into various price points. Like this neighborhood is the $300,000 houses, and these are the $400,000 neighborhood. I don't really know Wyndham that well, but I guess it was like that. So she pulled in, and I guess assumed because Willie looked like a fellow of modest means, she went to pull into the least expensive neighborhood. And I said, "No, we really don't want to pull in here where the small houses are. Where do y'all keep your large houses?" And she said, "Well, all right." So we kept on going, and she pulled into a very, very nice neighborhood. And there was a number of houses for sale. And Barbara, his wife, said, "Well, stop right here. I'd like to look at that one." And she went, "Oh, well, wait a minute. That house is $800,000. And I said, "Well, go ahead and pull on in." So we pulled in the driveway. Mrs. Edwards and the realtor went in and looked at the house. And Barbara came out and said, "No, I don't really like that house." And so we went down the street a little bit further, and Ms. Edwards saw the next house and said to the realtor, "Let's pull in there." And the realtor again said, ma'am, that house is like $1.1 million. And I said, well, just go ahead and pull in the driveway. So Ms. Edwards and the realtor got out. They went in the house, checked out the house, came out, and Barbara says, I like that one. I'll take it. And the realtor said, well, what do you mean you'll take it? I mean, we've got to get an application for financing, and we're going to have to check your credit and all that. And I said, no, ma'am, we're not going to have to do all that. You're going to have the seller's lawyer call me. We're going to draw up a deed, and I'm going to write you a check for $1.1 million. And the realtor's eyeballs like roll back in her head. And I said to her when she left the Edwardses out of my car back at my office, I said, you might not want to stereotype next time because you can tell by looking at people how much money they have. And Willie's got plenty. So anyway, Willie bought his house. He and his wife bought their house and paid cash in Wyndham.
John, is that what keeps you going? Being able to make a difference for people like that?
Oh, sure. Oh, yeah, absolutely. Yeah, it was the fun of kicking Norfolk Southern's butt. Sure. It's the thrill of the hunt, yes, and helping somebody like Willie Edwards. He was a completely innocent victim. He did nothing wrong. He was where he had every right to be. He was doing his job. And Norfolk Southern didn't mean for it to happen. They just messed up. But their idea of full and fair compensation wasn't the same as what those 7 people that day felt was full and fair compensation. And I'm proud to say at the time that was the largest verdict in Virginia for one personal injury case. It's been many times eclipsed since then. But $10 million at the time was the largest single verdict in Virginia, I believe.
One thing I'd like to share is before I started working at Marks & Harrison, I would take my son to this gymnastics place every Sunday morning. And I would always drive by Marks & Harrison, and I'd always see a Mercedes parked in the corner on a Sunday morning, Sunday early afternoon. And it wasn't until I started working here I realized that's John Shea. The parking lot's empty, but that one Mercedes. And so, John, you have been an incredible example of what hard work is. And it sounds like to me that being able to go after the corporation that's not taking safety seriously, to help give back something to people like Willie Edwards, that's the thing that I get from you as to what keeps you in here.
It is, yeah. I mean, it's just simply no substitute for hard work. Ted Turner said it best when they asked him, what's the key to success? He said, simple, early to bed, early to rise, work your ass off, and advertise. And that's what I adhere to. I am not the smartest lawyer at Marks & Harrison. I haven't ever been. Roger Krieger is. But I make up for it just by being here before everybody and leaving after everybody. There really aren't any geniuses in the courtroom, I don't think. I think they're just drudges in the office. What did Bobby Knight say? Everybody wants to win. The question is, do you have the will to prepare? So it's just hard work. But it's also fun. I still enjoy it. I blessedly don't have to keep doing it, but I still enjoy it at 71.
I'm sure we'll see that blue or no, it's no longer a blue Mercedes, right? It's a black Mercedes.
Yeah, well,
One of
we all have our weaknesses, and one of mine is cars. I have some other weaknesses, but
John, you are not alone in this room, and I'm not talking about the guy who drives a Honda Civic.
yeah.
A guy named Niall Abuzaki to your right, who also has a thing when it comes to cars.
John, you're inching close to 50 years of practicing.
Yeah, 45.
What keeps you going today? After all these verdicts that you've received, what brings John to the office on Sunday morning?
I don't know. I just still enjoy it. I mean, it's still fun for me. I have been blessed, to quote my favorite musician, Pitbull, I don't go to church, but I've been blessed. And I just still enjoy it. I never feel like I'm going to work. 95% of the time, I enjoy it. I can't say I have quite the same energy level I did when I was 31, but I do enjoy it. And every case is different, really. Every client is different. It's a new story, different people. 95% of the people that walk through the door are good people. They don't really want to be in an injury law firm's lobby. They would prefer to be somewhere else. But they're deserving people. They're good people. The insurance industry's job is to close cases. It's not to seek maximum compensation. They need you. It's still fun. So why not?
Violating the number one rule that we all know as trial attorneys, which is don't ask a question in cross that you don't know the answer to, held the big guy honest, and that was Norfolk Southern. Today, how does Marks and Harrison and how does John Shea continue to do that?
Well, thorough investigation of every case, understanding the damages carefully, getting to know the harms and losses that your client has sustained. We are committed to investing and spending what's necessary. Almost every mediation I go to, I tell my insurance friends, particularly if it's a close case or a tough case, you might win, you might beat us, but you will not outspend us and you won't outwork us, because you've got to be able to spend what's necessary and put the resources behind the case to be successful. For a lot of the big cases, it's a war of attrition. They're just trying to wear you and your client down. I think we're committed, and all the good personal injury firms, not just Marks and Harrison, all the good ones are committed to spending what's necessary and doing what's necessary to give the client a fair shot. And you're up against an adversary with essentially unlimited resources. It's not a level economic playing field. The insurance industry has all the money they need, so you've got to be capitalized and be able to stay the fight. And if you don't, because every firm has its limits. I mean, this is not a bank. We don't print money here. We know when to joint venture cases, when to put teams together, and we've done that in mass tort cases to go against defendants when there are multiple people injured, class action type stuff. We join up with other good law firms around the country and even locally.
John, can you talk a little bit about the trial? We hear a lot about the trials dying. It doesn't exist nearly as much as it did, or doesn't take place nearly as much as it did a decade, 2 decades, 3 decades ago. Is that true from your perspective? If it is true, why? And is that a mistake?
Well, there's no doubt that less cases are being tried now than used to be. And I think it's a function of the growth of mediation, which is a wonderful tool. All cases are risky, stressful, time-consuming. I think it's also the cost factor, particularly in personal injury litigation, the cost of medical testimony, the doctors and the other experts, the costs are exploding. There are more cases, I guess, so the dockets are maybe heavier than they used to be. So there are fewer and fewer trials being held. There's a lot of cases are still going deep into litigation, but I think there are fewer trials being held. And I think that's a function of the growth of mediation, cost, and clogged court dockets, particularly over the last 2 or 3 years with COVID. It's been hard to get trial dates. So that's contributed to it recently.
How do you see that impacting this practice area? I imagine if it continues like this and we continue to see fewer and fewer trials, attorneys get fewer opportunities, judges have fewer opportunities to oversee these cases. Is that a problem?
Yeah, I do think it's a problem because you can't become a trial lawyer by reading it in a book. You've got to go and do it. And once you do it a few times, they pay you more money, frankly. But you've got to go and do it. You've got to be willing to try it. The insurance industry, our colleagues on the defense side, they know who will do it. They know who will go and actually try the case. And you have to be willing to lose. If you can't afford to lose, then you can't really be an effective plaintiff lawyer. You have to be able to lose. So it will be a long-term problem for firms, the plaintiff bar, and for the public if there aren't lawyers who really do go all the way to the mat. And I hope that the young lawyers will be willing to do that.
If you could give some words of advice for those young lawyers, what would it be?
Well, we've already touched on the hard work aspect of it. There's very little substitute for long hours in the office. Be willing to take the risk. Don't be afraid of losing, because you will lose some. I'm not saying that you don't settle there. Most cases probably should be resolved. Most cases have pluses and minuses, and ultimately the client decides. The lawyer advises, the client decides. But you can steer your client, encourage your client to be willing to take the risk and go to trial. And there are a lot of tools to help with that. High-lows or wonderful vehicles. You can guarantee your client at least some recovery, cap the defendant's exposure on the high end. So that's a tool to provide some incentive for the plaintiff to go forward because they know they won't walk out with nothing. It takes the cooperation of the defense, but oftentimes they're interested in doing that. Arbitration is another mini trial alternative that I have used. I usually do 1 or 2 arbitrations a year, in essence, trying it to a judge or a retired judge. But basically, you got to do the work in the office and then just go try it and trust the jury. As Judge Randall Johnson of Richmond Circuit Court used to tell me, Mr. Shea, when I was arguing about something that I didn't like, he would say, well, you're right, Mr. Shea. Our system's not perfect. It's just the best system in the world. So you got any more motions you want to bring on or whatever? So it's not a perfect system, but our founding fathers had faith in the civil justice system, and we got to have faith in it too. It's the only thing that keeps the defendants honest. The only thing that brings them to the table is the fear of the 7 citizens. It's pure citizenry. It's pure justice because they're the ones that decide. That's what I would encourage the young lawyers. Have faith in the jury system. It usually works. I've had my heart broken. I've left there not understanding. And I don't try anymore a huge number of cases. And I never tried a huge volume of them. I tried to be judicious in the ones I picked. You want to try your good cases and settle your bad ones. But trust the jury. They usually get it right. They usually get it right.
John, do you have a favorite part of trial?
I think the most important part is voir dire. But I would say, believe it or not, putting on the lay testimony. I enjoy the before and after witnesses. I think that's a real key. I think plaintiff lawyers particularly get too hung up with having the right experts and battling over the nuances of the medical testimony, whereas good friends, co-workers, I think have a huge impact on jurors. So I enjoy finding the lay witnesses, developing them, getting them ready. You and I had a case over in Charles City where we didn't have good lay testimony, and that was one of the weaknesses in an otherwise pretty strong case, but our client was sort of a guy that stayed to himself and didn't have a good, strong marriage, and he just didn't have a lot of good testimony about how his particular orthopedic injuries had affected him, and I think that was a weakness in his case. So if you have good, strong lay witnesses, and I enjoy working with the lay witnesses.
Why is voir dire, in your opinion, the most important part of the trial?
Because they're the decision makers, and you got to make sure that they're people who will give your client a fair shake. Because there are people who have been poisoned, in my view, by the insurance industry's campaign over the last 40 years to poison the jury pool into thinking that it's a big lottery, that runaway juries, that the plaintiffs are looking for free money. Because you got to remember, big business, big industry, they can buy state politicians, they can contribute to national campaigns, they can try to have huge influence. But on the jury, there's nothing they can do. And that's what they're really afraid of. So the way they do it is indirectly by trying to poison the jury pool into thinking that plaintiffs are all fakers. And I mean, yeah, we get 1 out of 100 people that walk in the door who really aren't hurt, who really are looking for something for free. But that's 1%. 99% are solid, legitimate people who have legitimate injuries. So you got to make sure that you don't seat anybody who already has been poisoned. So you got to weed them out to give your client a fair shake.
What are some of the things that you do during voir dire to try and give yourself the best shot at doing that?
Just get a conversation going. I'm a disciple of David Ball, the jury consultant David Ball from North Carolina, and just get them talking to you. Sometimes they'll talk among themselves, get them to reveal. And most of them, if you get them talking, if you talk less and let them respond more, they'll tell you what they're thinking about things and what their biases are, because we all have biases. Everybody brings biases to everything they do, and you want them to tell you what their biases are.
Now, John, there'll be people in Virginia who will say, well, all right, cool, voir dire important, right? But we don't do voir dire in Virginia. You ask a few questions, you sit down. What do you tell those people?
Well, you try to approach the court ahead of time and try to condition the judge to let you do maybe a little bit more. Because you're right, in Virginia, we don't have California style voir dire where it goes on for days and days and days, you know. Our judges are more likely to say, oh, Mr. Shea, they're all going to be good people. They'll all be fair. So you need to precondition, warm the judge up a little bit on the importance of voir dire. You can try to use supplemental jury questionnaires. I don't have a lot of success, frankly, in convincing state court judges to allow us to use those, but I have done some, had some success. And that way you can get a lot of information ahead of time so you don't have to waste your precious questions on preliminary stuff. That's about it, really. You just do the best you can. It's not going to be everything you want. Some judges will let you spend a fair amount of time, particularly if it's a fairly significant case. If it's a very modest, run-of-the-mill case, you're probably not going to be able to convince them to give you too much time. But in a significant case, significant injuries, and the defense ought to want it too.
Niall and I both are of the mindset that voir dire is a critical part of the case, and it's vital to do well, and that if you are talking more than the jurors, you're doing it wrong. But something that I've found that's funny, at least on the civil side, as a plaintiff's attorney, is I'll get up and I'll do this long voir dire, and I'll sit down, and then the defense attorney gets up, and because you can all be fair, right? And trying to act like he didn't have any questions, but he did, and I asked him all for him, right? And it's something that I've found that happens more often than not. But I agree with you, John. The defense does want voir dire, and that oftentimes they benefit from the work that we do getting the information.
Well, we get to go first, so they get to ride along with our questioning, and we weed a lot of the basic questions out ahead of time. And they want to do everything to downplay everything. Oh, it's no big deal. Y'all will all be fair, right? And so that's they're trying to set the mindset that it's not a big deal, and so the jury won't return big deal money.
Well, John, it's been a true pleasure to have you here. It's a privilege to get to come and work with you every day. But we've asked you a lot of questions about your career, and obviously you've had quite a successful career. I want to ask you a question about the next 5, 10, 15, 20 years. Are we still going to continue to see that Mercedes parked there Sunday mornings?
The goal is at least 75. So I'm counting on another 4 years at least, and then we'll see, because I'm 71. We'll see. Plan to leave before then. We'll see what the story is after that. Marks and Harris are going to do fine whether I'm here or not. They asked Charles de Gaulle when he retired as president of France. He was asked by one of the reporters, well, President de Gaulle, you've been president for 20 years. So what's going to happen to France now that you're retiring? He said, I don't know. Graveyards are full of indispensable men. There was a Marks and Harrison before me. There'll be a Marks and Harrison after me. A lot of good lawyers here. Plenty of people keep working, keep getting after it. I'm not worried about it. They'll do fine. We'll do fine.
John Shea has left his mark not only on Marks and Harrison, but on the civil side of trials. And we appreciate you taking the time, sitting down with us today, and giving us a glance of what you've done for the last 45 years.
Well, I appreciate the opportunity to be here, and I think it's a great thing y'all are doing. You can't talk about trial work and personal injury work enough, so I'm glad y'all are doing it.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.